going to skip all this and move on to copyright, which I highlighted slightly earlier. There is a provision in Singapore that talks about infringement by import. So if a person import a product without license of the copyright owner into Singapore for purposes of sale, distribution, etc., and he knows or ought reasonably to know, which is a deeming constructive notice provision, that the making of the article is without the consent of the owner of the copyright, that's infringement. Now, there are two levels of consent. The first level of consent is it was imported without the license of the copyright owner. The second is it was made without the consent of the copyright owner. Okay? So, what is the owner of the copyright? The owner of the copyright is the person entitled to copyright to make an article in the country where the article was made. So you might remember me mentioning this earlier. Really, so quick? All right. I'm just repeating what I said earlier when I talked about copyright. So I'll move on. Okay, I was going to talk about software licenses. It's an interesting area because how do you copy software and use it? Because software is generally installed, and how do you transfer the product of a software by copyright? That transfer, is there an exhaustion? But I don't think I have time, and since none of the speakers are talking about this issue, I will skip it altogether. Trademark rights is interesting. We went into quite a bit of discussion in relation to the Indian position earlier, and I realized when looking at the presentation earlier that there's a lot of parallel in the provisions, largely because I assume there's been some influence by the UK provisions, which is almost in pari material to both our laws, save for little changes. And much of the UK position, as I understand, derives from Article 7.1 of the European Directive. And so in Singapore, use of a trademark in relation to goods which have been put into the market, which are the same words you have in India, whether in Singapore or otherwise. So in Singapore, we realize that put into the market could be an issue of whether it is the market in India or the market in Singapore or the market at large. And our legislature was very precise in saying, oh, forget that issue, let's make it clear. It must be whether in Singapore or outside Singapore, which meant internationally. So if the goods were put under the trademark by the proprietor of the registered trademark or with his express or implied consent, again, conditional or otherwise, it is not an infringement. But it is curious here, it's slightly different from the provision we see with patents. Now it says the consent, whether it's conditional or otherwise, which you understand now is a deeming provision, it goes further to say the consent could be implied as well. It does not need to be expressed. So there might be a possible argument to say that the trademark situation for international exhaustion appears even wider, but I'm not so sure. So again, these are limited. It's the same as the Indian situation, I think section 30 here, where if the condition of the goods have not changed and so on. So I will not belabor the point as well. But what I find very interesting, and this is coming to the end of my presentation, in case the second bell rings, is that under our registered designs law, the same exhaustion provision exists. It's never been tested. So we don't really understand how it might work. But again, there is this concept of putting it into the market, although a slightly different word is used, placed into the market. I submit it's probably an oversight, but because I can't tell the difference between put and place. Okay? And again, consent, conditional or otherwise, but this time without explaining whether it can be implied. It's silent. So even under our Registered Designs Act, there are all these concerns. So this is the final last slide, I promise. There's some food for thought that I feel might arise from the discussion we have. With relation to patent rights, there's a question of processes. It's not touched on by the laws. And I find it hard to imagine very specific situations of exhaustion that could apply to processes. Yeah. Copyright as well, there is a question of whether, this was the topic I didn't have time to talk about, but I'll just leave this thought with you, whether if you were to impose a contractual term on a transfer of a copyright license for software, could that sort of skip issues of exhaustion? Trademark rights. A recent case has arisen in Singapore where the question of put into the market was at issue. And put into the market here is not a question of whether it was put into the market in Singapore or outside Singapore, but what is put? When an item is put into the market, is it put in the market when it has been imported and it's now in a warehouse? Has that situation resulted in a product being put into the market? Or must the product have been shipped to a distribution warehouse? So when it enters a warehouse for distribution or a distributor's premise, it is put into the market? Or must it move all the way to a retail store before it's put in the market? Or must the retail store advertise the fact that it's selling the product before it's put into the market? Or when somebody walks through the door and purchases the product, that it becomes put into the market. And that was very relevant in a case in Europe. A very, very good decision on Article 7, and I encourage you all to read it if you're very interested in this topic. It's called Peak Holdings, Elecon. It discusses where put into the market starts and when it ends. And in Singapore, we had to deal with this issue, but unfortunately, the judgment is not out, and because I represent that case, I do not wish to talk too much about it in case, I don't know whether this is recorded, but in case my arguments get posted around and if it goes on appeal, I have to deal with it in an unexpected way. Okay, so thank you very much. I probably should step down now because I think the next speaker is impatient. Thank you.